right, good afternoon. My name is Jacoda Espinoza. I am the Director of Communications for Fair Fight Action, one of the 6 plaintiffs in the federal lawsuit Fair Fight Action, Inc. v. Raffensperger, which began trial today. Behind me are representatives from the plaintiff organizations who our counsel, Allegra Lawrence Hardy, will introduce momentarily. We're also joined today by Ms. Hardy, who is the lead litigation counsel for the plaintiffs. In a few moments, Ms. Lawrence Hardy will be sharing remarks on the case and today's opening statements, followed by a brief Q&A. Since the start of this lawsuit, Fair Fight Action has centered real voters and their stories because we believe that is one of the most effective ways to demonstrate the barriers of Georgia's election system. This will continue throughout trial, where more than a dozen Georgia voters from across the state will testify about the obstacles they faced trying to exercise their fundamental right to vote. The voters traveling to trial are just a tip of the iceberg, as they represent countless voters in their communities who have been shut out from the voting process. Our hope is that by memorializing these stories in an official court record, we will help shape the future for Georgia voters, in addition to becoming a critical piece of our history. And I will now turn it over to Ms. Lawrence Hardy.
Thank you. Thank you all for joining us here on this very exciting day. I am Allegra Lawrence Hardy, and I am privileged to serve as lead counsel on behalf of all of the plaintiffs in the Fair Fight Action versus Raffensperger litigation. Many of you were with us 3.5 years ago when we filed this lawsuit. It was a little chillier that day when we stood in front of this courthouse. More than 3 years later, after we filed that suit that challenged the constitutionality of Georgia elections practices and alleged violations of the Voting Rights Act of 1965, we finally had our first day of trial. Today marks an extremely important moment in history. This morning I quoted Congressman Lewis in my opening statement. I'm now going to quote my new Congresswoman, Nikema Williams, who said, quote, "Those who came before us sacrificed too much for us to turn back. In the spirit of good trouble, Congressman John Lewis taught us we must protect the sacred right to vote for future generations," close quote. That is what we are here to do today. After repeated attempts by the state to silence the voices of the voters by asking this court to throw this lawsuit out multiple times, these Georgians refused to be sidelined. So we are finally here. We have finally had our first day of trial, and these voters are finally going to have their stories told in the first voting rights case to be tried on the merits in the Northern District of Georgia in over a decade. This case is also among the first full trials involving a claim under Section 2 of the Voting Rights Act of 1965 after the Supreme Court's Brnovich decision, which so many of you covered last summer. I am pleased and honored to be joined here today by individuals who represent all of Georgia. These are voters and would-be voters who are at the heart of this case. These are the volunteers who work at the grassroots level to protect voters every day. It is the Georgians who have always been at the center of this case, and they will be at the center of this trial. The court will hear directly from voters and those who tried to vote but were disenfranchised. The court will hear from these Georgians who were burdened and disenfranchised because of the Secretary of State and State Elections Board's policies and practices. We are pleased to be joined in this litigation by 4 Georgia-based churches. Ebenezer Baptist Church, the spiritual home of Dr. Martin Luther King Jr. and his father, Martin Luther King Sr., as well as the home church of the late Congressman John Lewis, whom we all know was a tireless advocate for voting rights. We have Beckington Missionary Baptist Church of Liberty County, a congregation dedicated to civic engagement, demonstrated by its rich history, formed as slaves became free and decided they wanted to worship on their own and decide their own values. The 6th District AME, leader of more than 500 AME churches in the state with a mission of advancing social justice, and the Virginia Highland Church, a leader in the fight for moral, spiritual, and political change. We also have 2 civic organizations, of course, Care in Action, and we heard from Care in Action today on the stand. This organization is dedicated to advancing the rights of domestic workers that also traces its roots right here to Georgia. We all learned that today while she was on the stand. And Fair Fight Action, a voting rights group committed to educating and engaging voters, particularly in the historically marginalized communities across our state. These leaders, who I stand shoulder to shoulder with, represent so much more than a name or a building. They represent entire communities that share as a core value the importance of the fundamental right to vote. In opening statements presented this morning, we outlined how, through deliberate choices, the Secretary of State and State Election Board have erected a series of roadblocks that impose unjustifiable burdens on eligible voters and would-be voters in violation of both the Constitution and the Voting Rights Act. The practices challenged in this case permeate every stage of the voting process, and they compound the obstacles Georgians face when trying to exercise their fundamental right to vote. We first challenged the Secretary of State's exact match policy. 2 components of this policy that we challenge, both the method of which an applicant's U.S. citizenship status is verified and the way in which an applicant's identity is verified. We raise and are extraordinarily concerned about the rates at which registrants of voters of color are placed in MIDR, the pending status, at a rate that is up to 10 times higher than that of the rates for non-Hispanic white registrants. Our experts will testify to this. We'll hear from a would-be voter who became a naturalized citizen after she was adopted from Korea when she was just 7 years old. Many years later, after presenting her naturalization certificate, her Social Security card, her out-of-state driver's license, her marriage certificate, and closing documents. What else could she possibly have had to present? All related to her residence in Georgia. She was denied a Georgia driver's license and therefore denied the ability to register to vote on the basis that her citizenship could not be proven. Just one example. The second practice we challenge is the mismanagement of the voter rolls. In 2018 alone, Georgia removed over 68,000 voters because of felony convictions. This was the largest number of felons removed from the rolls by any state in the nation. We will in this trial hear from a voter who experienced issues resulting from Georgia's mismanagement of the voter rolls. After he completed his felony sentence, he registered to vote for the 2020 general election. After registering, he logged onto his My Voter page to check his status, and while his personal details were correct, the voting district, precinct name, and polling place were not. He sent several requests for assistance to the Secretary of State's office. All of his requests went unanswered. The issues continued when he requested an absentee ballot, which he never received. With no assistance from the state, He finally figured it out on his own and made arrangements to vote early. It shouldn't be this difficult. Finally, we challenged the lack of training regarding the cancellation of absentee ballots. In 2018, you all remember this year, that's when we filed this lawsuit. The average wait time for a Georgia voter was 21.7 minutes, or 2.5 times the national average. We have evidence that when a voter must cancel their absentee ballot, it takes even longer. For example, we'll hear from a voter from Cobb County who initially requested an absentee ballot, but later decided to cancel his absentee ballot and vote in person. He had a long day at the polls to make that happen. Throughout this trial, we will demonstrate the numerous and various choices available to the Secretary of State and the State Election Board to protect access to the ballot and cultivate uniform practices across the state so that an eligible voter can be as successful in making their voice heard in one county as in another. And in stark contrast to the options available to eliminate unjust and discriminatory barriers in Georgia's election system, we will show at every turn the Secretary of State and State Election Board's actions that demonstrate an intent and evidence of disenfranchisement of Georgia voters. It is a true privilege for every member of this trial team to join with the brave voters, the brave would-be voters, the persistent volunteers to advocate on behalf of the powerful, diverse, dedicated organizations represented by those who stand here with me. Their perseverance and, yes, their faith have brought them through voting challenges and over 3 years of litigation, through COVID, through motions to dismiss and motions for summary judgment and trials being reset to this day. And we look forward to using these next few weeks to amplify their voices and share their experiences with you. We thank you so much for your time today, and we will now take questions.